The evidence seems to indicate that you're watching Dolly Vision.
Footsteps down the hall. Fingerprints of the dead, cold as stone. He's got the scoop, that's the route down known. Dolly Vision headlights, King of Peace. Truth unravels, crackling through the heat. Lost soul shining, head goes in the night. Rock the truth while live on air light. Toughen up, Dolly Vision's dreaming real. True crime scene flash feels so unreal. YouTube madness like share, subscribe. Jack's on fire, burning the world's fire. Where's the baby missing shadows crawl? People whisper footsteps down the hall. Fingerprints of the dead, cold as stone. He's got the scoop, that's the route down known. Dolly Vision headlights, King of Peace. Truth unravels, crackling through the heat. Lost soul shining, head goes in the night. Rock the truth while live on air light.
What up, YouTube? It is Dolly back in the house again today. As you see, Bryan Kohberger is in court trying to fight the death penalty. All right, his trial haven't even started, but his lawyers are in court trying to take the death penalty off the table. Okay, and we're going to be watching this. Also, don't forget to leave your DNA on that like button, just like Kohberger left that knife sheath at the Idaho 4 house. Okay, I want your DNA all over it, all over it. And also, if you're brand new, make sure you sub up the channel, ring the bell for notifications, and all that good stuff that you do as a good viewer. I hope everybody is having a great day. It is good to see you guys jumping into chat so quickly. There's like 300 of you here already. So good day to everybody. Let's make it a great day, and let's make sure that Bryan Kohberger's death penalty don't get taken off the table, and this man is executed for these horrible, heinous crimes that he has committed. Now, I do know that there are people out there that actually believe that Kohberger is innocent. You may be one of those people, not Dolly. Now, I believe Richard Allen is innocent, but I do not believe that Kohberger is. All right. So court is we're going to start it at the beginning so we can review this case today. Leave the death penalty on the table. I absolutely agree with that. You know, what this man did is heinous, right? In the middle of the night, he slips into the back door of the house, allegedly, you know, goes upstairs, kills the two girls. Sad. And then comes downstairs and kills the guy and his girlfriend. And, you know, we still had the roommates that seen him in the house, right? Bethany and Dylan, ain't it? Ain't that what it was? Oh, interesting. I haven't heard about this. Well, here you go. The creeper is guilty, in my opinion. Yes. And, you know, listen, this guy has been motioning the courts, and his lawyers, you know, they got the court case moved. Sway says absolutely guilty. I'm still 50-50 on the Kohberger case, says Kaya. I don't know if I'm 50-50. All right, here we go.
Be seated.
I believe they are going to live stream the trial, so we will be able to watch it and review it. Definitely get those likes up for me, guys. I appreciate it.
We are back on the record in Ada County case CR 0124316665, State versus Kohberger. Counsel are present.
That's who I'd be blaming it on, the roommates.
Mr. Logsdon, is that correct?
That's correct, Your Honor.
And counsel previously identified for the state are present as well.
Ride the lightning.
Mr. Thompson going to be on the...
He's afraid of the firing squad. Yeah, right. I would be too.
Okay. All right. So Mr. Thompson is appearing remotely. This is the time set for a number of hearings this morning. Yesterday afternoon,
We'll take a vote in a little bit.
Order, by which the proceedings would be handled.
You can't stop looking at his crotch.
As well as designating the amount of time, generally speaking, that the parties or that the court will devote to the issue. The court has received extensive briefing by both parties and has reviewed it all thoroughly.
There's a lot of
So,
circumstantial evidence in this case.
First thing I want to address, just
hey guys,
because
good
the
to
public
see you.
is not here this morning. I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court
Granny
allowed
says,
Mr.
ride the
Kohberger to
lightning.
appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes.
I say they drag him out there in an orange jumpsuit like the criminal he is.
The first matter we have to
That
take up this
cone.
morning is the objection to the testimony of Dr. Barbara Wolf related to the method of execution.
Definitely
So
over
let's,
drugs.
proceed with that. The state can be heard.
Give him the firing squad.
Thank you, Your Honor. Our objection on this witness is really just the ripeness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not right before we have an evidentiary hearing on it.
All right.
That's the extent of the objection.
All right. Thank you, Your Honor.
That's what he should
Ms.
get.
Taylor.
Let me get the magic bullet.
Your Honor. Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with
I'll
having
do it.
somebody sit on death row when there's no meaningful way for them to be executed.
Yeah, there
Dr.
is.
Wolf's testimony will highlight for the court some information that may come up if Mr. Kohberger's ever convicted, and if there's a death penalty, and if he faces firing squad as one of the options.
Well, I will say I'm not particularly convinced about your, well, I'm going to save that till we get to the merits of it. Let's talk about whether we need to hear from Dr. Wolf first. So I go continue.
Your Honor, I think that Dr. Wolf's testimony would provide the court with
Yes, Debbie.
information about conscious pain and suffering, awareness of that pain and suffering, which matters for the Eighth Amendment, as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision. And then in 2023, instituting it again. But this information about consciousness and
He's
pain and
done.
suffering happens in that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you.
I think it's humane. I
Your
mean,
rebuttal.
firing squad is a quick way to go. One to the head.
Very briefly, Your Honor. I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right. Thank you. All right.
Yes, the roommate Dylan and
The
Bethany.
court,
Red
having
flags
reviewed the
for sure.
materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general
Hey,
testimony
Pat.
would be that would allow us to discuss
Laura.
the issue. And so
Ducky.
for the time being, I'm not going to
JJJ.
hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony.
Yes,
The
firing squad's real.
declaration, is an appropriate proffer. I will hear the merits of the
Put 'em in the
motion
scope, be
based
like,
upon that
bow.
proffer, next. All right. So let's hear that from the defense.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration.
Yes,
The
Melissa.
information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf. That's not contained in the declaration. And I would like to make that part of the record too from her. So
I'm
if the
trying.
court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
I'm
You
okay,
can,
Pittsburgh
submit
nurse.
that
A
in
little
your
bruised
file. I
up.
don't hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody.
Give me a job. I'll do it. I'll do it.
When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein.
Yeah.
See how that issue is universal.
Your Honor, I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only
I know,
person
Melissa.
that has ever had that happen. Not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time.
I think
But
they should
since we're talking
stab
about
him.
Idaho, I
Then
think we should
harpoon
look
them,
at
and
what
then
happened
they
in the
kill 'em.
pseudo case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their
have obtained them twice now, since then.
He said we kill
obtained
people.
them twice for Creech. Yes. Now something has changed in the death chamber for how they will try to execute Creech. I don't know what that is.
Hey, Sarah.
That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent
Hey, Amy.
decision by the district court approving that procedure. I think that's
Your helmet and crayons from
And I
Santa
think,
Claus.
you know,
Funny,
looking forward,
funny.
we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his
There you go, Miss
execution is moving
PJ.
forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when
I
I'm
fell on my
standing
head,
before you,
JS.
representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of
Thank
executing
you.
someone.
Thank you.
The
Mad
firing
love to you.
squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston, in
Happy
our
birthday,
briefing,
Ann.
is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bayes decision. When you think about it coming off in light of the Bayes decision, and you look at what's happened since the Bayes decision, and we're going to talk about that a little bit later.
I'll pay for the
Today, when we're
bullet.
talking about evolving standards of decency. We'll talk about how things have changed in this country since then. But for these purposes, when you look at that, and you
Right,
realize
Sinclair.
Idaho
Right.
brings it back in 2023. They bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody.
Don't be
And that's
Dolly
the
at
real
home.
problem here. The firing squad hasn't been funded well enough to be built. They're
What? I'll
They're
do it.
building it right now, as I recall from the
Judge said they're building it right now. They're buying the guns.
But I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way
I can
our
get the drugs to
statute
kill you right
lays
on the
it
corner
out,
down the
too.
street.
If you read our statute, and the court just summarized it, it's lethal injection unless it's not available, and then it's going
Thank
to be
you,
the
thank
firing
you.
squad. But the way that's written is that it's firing squad unless the director of the Department of Corrections says, I have the chemicals and we can do lethal injection.
I say they
And I think there's
K-bar 'em.
5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection.
Pro-deaf, yes.
That is problematic. There's not a choice or an election, and other states have an election for the condemned person to choose from, but Idaho's not allowing that. Additionally, the information that I think is really important
I'll loan
to
the
the court is
mine,
to
okay?
understand things and advances that have happened in understanding conscious pain and suffering. If
Lead
Dr. Wolf had been
poison
allowed to
bullets.
testify, she would tell you that she relies on
Oh, I love
studies
that.
from 2010, a working group from 2010, and a book that was
there you go.
published later than that even. And that's post the Bayes decision. And that talks about understanding what a person is
Yeah, it's a
conscious
little bit
and
better
aware of
today.
when they face the
Right
firing
there.
squad. That's information that's important for the court when considering whether or
DK
not to
is
strike the
innocent.
death penalty, because Idaho's means of execution really doesn't exist.
Okay. Challenge
Can I
Daily
ask
said he's
you,
innocent. He shouldn't get the firing squad.
Even if your motion were right.
Welcome to the Dolly train. Jump
and
aboard.
even
Thank you.
accepting
You're sitting first class today,
current
girl.
Means
Welcome.
of execution are either unavailable or would violate the Eighth Amendment as
Hey,
cruel and
TNT.
unusual. How do you get around Buckwell? You've not provided a alternate means of execution.
PJ says, hit that like
Well-
button for us, guys. Appreciate it.
And I know, and I understand from your perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition proceeding, provide a available or an alternate, I should say, means of execution.
I'll do it.
I would say, to
volunteer.
Your Honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue overall.
I don't think it does. And I think that the separation and the difference is
Caution
that
tape. Yes.
we are in a place where we're preparing this case to go to trial. We represent
I
Mr.
took it
Kohberger,
down.
who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that that involves, all of the requirements that are upon counsel that take a lot of time, a lot of work.
Definitely, guys, be nice. If somebody disagrees, we're not here to fight. We're just here to listen to the case. Some people think he's innocent. Some people think he's not. That's perfectly fine. Okay. But be respectful to each other. All right. I appreciate it. Love you all.
And a lot of money to do this. And so I think when we're looking at the constitutionality of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in this?
I wonder why.
You're saying take the death penalty off the table. Don't let the state put on that evidence because the current methods, in your view,
Yeah, I know, PJ.
are unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before
Shea butter and goat milk's
that
in all my
sentence would
soap.
be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that that same
Maybe.
rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years when the way Idaho's doing it right now isn't really working. It's not a realistic option.
So we shouldn't kill him because
I
the way
think
y'all's
to
laws
have him
are.
sit on death row and say Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights. I just don't think that the constitutional protections allow that to happen. I think that.
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety. It is fear. It is the not knowing.
I mean,
Who cares about his fear? Okay, who cares? Who cares?
Ruled that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion, and I read that, I guess, more particular
Yes, he's there.
to the botched execution attempt versus sitting there
Right
for
there.
decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
And I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades.
It wasn't cruel and unusual when he murdered those
And no
girls and that
disrespect to the
dude.
anxiety Mr.
Ethan.
Creech felt, I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's
We'll give him some
different
anxiety.
when
How about that?
you're just starting out here in this circumstance.
Catch him in the firing squad. How about that now?
Thank you.
She worried about him dying. He wasn't worried about them kids he was killing.
Your Honor. I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today, but I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural, If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
I mean, I can do it for you guys if you need a hand.
Yes, Your Honor.
okay?
I don't see
Give me a
problem
rope
with that, because
and it'll be done.
deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging. And then after he was
just a
sentenced to
rope.
death, the state passed a law, made it electrocution. And the U.S. Supreme Court said there's no ex post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days
There
from
you
now,
go.
that
I
was
will.
only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T-Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech.
Mr.
So
Creech
there
had
really is
little
just no
veins.
evidence whatsoever to suggest that Idaho can't do this.
Couldn't find them
And
veins.
certainly not that it can't do this decades from now. And again, that gets back to the ripeness issue. Is it may be lethal injection, it may not, it may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know. in the
Beheading,
future.
there
That's
you go.
the entire reason the ripeness doctrine exists.
That would suck.
I also want to speak just briefly on the Bucklew point that the court brought up. What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established
Yes.
framework of how you can make an
You
Eighth
know he's
Amendment,
nervous.
method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today,
When I think Creech, I think of the Karate Kid. Sensei Creech.
Which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution, because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to,
Yes, they
at
have
the
it.
beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it.
Yes,
If the state wants to
Sinclair.
pass a law and do
They'll
this other
gas
method
your
that
ass.
he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless
The
there's any further
guillotine.
questions, we'd ask the court
Hang
deny
them
the motion.
Thank you. Any rebuttal?
for everybody to watch.
Just briefly, Your Honor.
They're worried about how he
The
feels.
distinction
Was
is not
did he worry about how them kids
us
feel he killed? I don't
being
think
on
so.
death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have any
understand.
case that says that?
I'm making an analogy with the troop versus
Quarter
police
him.
and
Oh,
the
yeah.
denaturalization with
Horses.
the
Time to some
dehumanization
2 horses
that
and let
happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been
another
thoroughly
state alone, them
controlled. I
old
understand
Sparky.
that. But when we're talking about the recent history of what
Guys, if you're just coming in, give this video a like. And when you do, shout out where you're watching from. Okay. What state you're watching from. Don't cheat though. Make sure you like the video first and then shout out where you're watching from.
what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about 2 pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant,
Michigan,
and we're talking
Texas.
about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that?
How hard is
right,
it to kill
fair,
somebody?
any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you. All right, court will
Alamo
take
City.
that issue under advisement and issue a written
Mass.
opinion with respect to its ruling.
Albany, New York. Nice
Next,
place.
I want to take up the objection to
East
Professor
Texas.
Kohberger's testimony.
Let's see if we can get to 600-700 likes. I say they give him the good old K-bar.
Your Honor,
Same
as the
way he
state
killed them
pointed out in its
kids.
Written objection. Professor Cover's testimony is
Is it
largely,
Cover or Kohberger?
I believe, I'll defer to defense counsel. Is it?
It's cover.
Cover, thank you.
Thank you, counsel. Professor Cover's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony.
And let the
state cited
family
to
do it.
Ybarra in its objection, and in Ybarra,
The
the Idaho Supreme Court
Gonclaves.
held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight
Hang
up
them high.
rejected a
There you
similar,
go, Snowflake.
attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received
What's up,
the
Michigan?
PowerPoint that Professor Cover would be utilizing,
Hey, Minnesota.
many of these slides are simply
K-bar was a knife,
simply
yes.
excerpts from statutes. This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis.
It is an
leading
organ.
to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis.
Killers have too
Thank
many
you, Your Honor.
rights. Wind and Whim. Hey, girl. Good to see you. 18 months. You've been here with me for a good bit. Big virtual hugs to you.
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was
Hey,
that they
Oregon.
wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination.
Nebraska just got legalized.
That's my
Oh.
first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover.
I
They
don't
want
smoke
that
anymore.
discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study
Hey,
can
Savannah.
explain it. The other point that I want to
DP by
make is
K-Bar.
that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did
Oklahoma.
was nowhere even close to what the study
Minnesota.
that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively
You need some
narrow
dolly
the
soap.
class of first-degree murders eligible
Awesome.
for the death penalty. But that's
We had
not
some new
a
Christmas
relevant
soap.
legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator.
He should be dressed in orange.
As
I
understand
agree.
Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided
That
to,
I'm a trial court and not the Supreme Court.
and I'm sorry. I
Need some
interrupted you.
K-Bar
Hairston
soap.
was
There you go.
decided in 1999.
Hey,
Which
Georgia.
was a long time before
Tennessee.
Hidalgo was decided. And so the United States Supreme Court has absolutely made
No,
the
nothing.
issue
Clean
right
as a judge.
and said we want to hear what the specific data is, and we
Hey,
extend
Kujat.
an invitation for that to be done. The study in Hairston was framed as,
Oh, we
did
have some good
Idaho's
ones.
method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That was
capricious
the claim of
application?
How come Richard Allen in Delphi gets treated so bad? He kills 2 girls, allegedly. And Bryan Kohberger kills 4 people, and they treat him like he's gold.
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether
Thank
or
you,
not an
PJ.
urban
That's
versus a
different from the
non-urban.
issue of what the relevant legal framework is with respect to
Queens, New
whether or
York.
not the aggravators are overbroad
Mother
or
effer.
inclusive.
I
as a
agree.
whole.
I agree. But before we get to even there,
Hey, hush,
Judge,
puppy.
which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which
Hey,
is a
Jackie.
legislative function that looks at the statute
Just Christine.
and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And
Rochester.
that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly.
I do believe in baby Jesus, but I'm an eye for an eye.
Doesn't do it
I'm in
based on-
capital
in fact,
punishment
she-
person.
Generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called
Amsterdam, New York.
The I can't remember what the name.
Clear.
The clear ones
Right.
were.
Right. But it is her study is a good foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right, but I guess my concern is that the Supreme Court, the outer Supreme Court, has said that that's not the issue. When we look at whether
Yeah, I'm
the,
okay.
aggravators
It's been 3 months now.
constitutional,
I haven't
being,
smoked.
Not sufficiently narrowing of the class of persons or crimes available for the death penalty.
Hey, Jenny.
The Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual aggravator and ask, with that respect to that aggravator, does it exclude sufficiently?
No, I believe you kill somebody, you deserve to lose
I
your
don't
life.
disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's
But it begins, Judge, with the definition of first degree murder. You start with the definition, which is very broad, of first degree murder,
which is why the aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Kohberger's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's part of the analysis.
I
of
mean,
the
everyone agrees the
eligibility.
statute itself as to first degree murders that are eligible is without more unconstitutionally vague. That's why the court has U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court,
Okay, Jackie.
the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said,
Yeah,
is,
they're trying to
of
take the
course,
death penalty off the table.
not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first degree murders?
When you smoke, it restricts your blood vessels.
First degree murders. And you look at those each individually and not cumulatively. My understanding is that Professor Kohberger's
Lethal
Kohberger's,
injection in the firing squad.
analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that.
Hit
Judge.
that like
read
button,
article.
guys.
The article.
Definitely hit the like.
That's the purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators.
Thank you,
and
Huntress.
then you have to,
BuyDollySoap.com.
look at what is the quantity of cases in Idaho that fall within both of those, paired against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
There you go. Thank you, guys. 800 in chat. Let's get those
Um,
likes up, please. Helps us in the
other
algorithm.
concern I have, I'll save that. I'm just now thinking about whether I need Dr. Kohberger. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier
you,
of fact
Karen's
here,
Corner.
and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad,
Thank you,
the
PJ.
aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession Arizona. It may genuinely.
No, I was just barely over 60,000. Not that many people left, believe it or not. So we were just barely over 60,000. So we ended up booting some people because they were animal haters. So we fell under 60,000. But no, not that many people left. Wasn't a big deal. We're glad those people left because we want good people here on this channel. We don't want just 60,000 anybody's. We want 60,000 good people.
Exists, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, you know, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago.
Right,
So
right.
For that reason, this court should hear that so that you can make a reasoned decision.
Yeah, we had to get rid of some bad people on the channel. They wasn't, you know, they thought it was okay to hurt animals, and we don't like that. So good riddance to the people.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates
it does look like her hair and her jacket
and
are the
potentially
same.
others as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply. The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was
Sorry, not
labeled
sorry.
utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice, again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack.
Love you guys too.
Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than,
Thank you, Jackie.
than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just
Yes,
reaching a different
Carol.
legal conclusion based on court records and providing a statutory analysis. And so
Okay,
the state
Jackie.
would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal? Oh, well, actually, that was the rebuttal, wasn't it?
If you'd let me talk,
I will indulge you for,
Thank you.
my schedule is already shot to hell, but we'll
Just,
indulge you.
we're gonna let you
We'll be able
talk
to get through
anyway.
in one day. I think that what the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means,
Thank you,
what
Cleos.
the exact records were, why she used those records, why the conclusions she drew were drawn. You have, first of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the
I
the
indulge
data.
you.
Or if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so,
And that law review article was as of 2019?
yes, yeah, yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So you, since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Thank you, Ann.
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. You know, other states have done the same at the invitation of the Supreme Court.
An
because
invitation of 4 of 9 justices.
Yeah, my dog is my kid.
Correct. It's still an invitation, and it's been accepted
Some Kohberger candles.
as an invitation.
We got Christmas candles, but no Kohberger candles. We don't support these monsters.
So I don't find that the proffered testimony of
Love you,
Dr.
fur
Kohberger
babies.
will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of.
I don't
what
smoke. It's
the
been 3
testimony would
months.
be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of
Right.
law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known
Lolo's good.
4-part My Fun Life standard.
I'm okay. Thank you.
Opinions as to the law are generally not admissible by experts.
I don't either. I think they should give him the death penalty.
The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither
I seen that,
relevant nor
Angela.
helpful, and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme
Oh,
Court
Wicked
through
West. I hope
the
you find them.
adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant,
Maybe. We might be able to
as
do
I
something like
understand
that.
from reading her article, Professor Kohberger's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders, which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case,
I don't
believe,
even
makes that
crave
clear.
smoking anymore.
The court is bound by binding precedent of the Idaho Supreme Court on this issue.
Hey, Claudia, jumping on the Dolly
Therefore, I
train.
don't
Come on
feel the
aboard,
need to
girl.
take,
We got plenty of room for you
Dr.
guys. Get
Kohberger's
on the
testimony.
train.
I think the
Dolly gotta
issue,
eat.
is
Okay.
sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up,
Claudia rocks. Hell
I
no.
certainly can.
My cat's named Cal.
invite
Cat
counsel
passed
and
away
Dr.
2 months
Kohberger back At a
ago.
later date to provide
Oh,
that
big
information,
hugs to you.
or to help clarify some of that
Oh,
information.
come in. Big hugs.
So from that
Get you another
perspective, I don't
cat
think
to
Dr.
love on.
Kohberger's, testimony is needed this morning. Now, I'm not going to
And thank you. You're sitting first class.
on the merits using Dr. Kohberger's analysis, because certainly counsel has the right to make a record of their argument on that.
Nah,
as well.
I just quit.
And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
Oh, the new soaps are Christmas cookie, candy cane. We have some other ones too, so make sure y'all check those out. Make great Christmas stockings, stuffers.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause.
You're welcome.
I will argue narrowing first. When it
That's
comes
good.
to the determination of eligibility, it begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase.
That
of a
sucks,
case.
Wild West.
And so our argument and our focus for this,
We have dog shampoo, Lolo's luxurious dog shampoo. I can't talk. Shampoo, and it's unscented and it's tear free.
issue is on the eligibility phase. What
Your argument
defendants-
doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection
Right.
phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
And we have a soap called Snowflake, okay, which is our Christmas soap. We
I
also
want to
have
be
spicy
clear
cranberry.
about the argument and eligibility that I'm talking about
And
the definition of first
holiday
degree murder
cheer.
and the aggravator statute, because our definition is so broad that there is no narrowing there.
Yes,
And
we still
so
make the
That is
honeysuckle.
an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't disagree with that, but it's certainly guidance for the court. You know, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse. And so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Kohberger in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Thank you, Angela. Yeah, I did a late night stream last night.
Your Honor, I guess I disagree that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse.
Yes, Heather, whatever. I like this judge too. He's going to shoot down that do away with the death penalty stuff. Over judge, yeah. This is them trying to get the death penalty thrown out.
When you have no narrowing, is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty.
From Cleveland, Tennessee. Good to see you. Glad you could be here with us today.
There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give
Thank you, Miss Margaret. Get on the train.
What that looks like.
You're awesome.
In the state of Oregon, which actually is on pause with its death penalty right now. A narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or another officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now,
You're on the
Oregon's
train.
hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a
Hey,
whole bunch
Misfit.
of mitigating
Good to
factors
see
for
you.
the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources. And the point was geography. It was in the context of arbitrary and capricious and not in the context of equal
But as I
protection.
understand your analysis is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your
statutory
claim is
scheme.
on the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level, when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those geographic centers in Idaho.
In terms of the southeastern Idaho,
2 in southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside the control. Well, I suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, and then I believe there was another one up in the 2nd district relatively recently that then was.
She's a good
resolved.
public defender.
and I can't dispute that. That still does not eliminate the fact that in Hairston, Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. for those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If I
names.
go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
I think, Judge, that the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
Right?
Yeah, I guess I'm not willing to concede that. And if it was something that, needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not state equal protection.
Thank
clause,
you.
but equal
645
protection
likes.
as
Let's get
applied
those
within
likes
Idaho
up, please.
Geographical.
If we can. Do it.
Would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but, if you're taking the data from Hairston, which was 1978 to 1995, and Professor Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
Have a case that indicates that an equal protection analysis can be applied
658. Let's
on
see if
its
we can get up to
face as
800.
opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which
Sir, you wanted
also
to say
has
stop talking?
created, in time, another dynamic of whether or not someone's charged with the death penalty
No
and
problem,
those
Andy.
costs at the time that he was charged. I mean, now it's different.
Hey, Stacy.
So, yeah, I'm not going to concede that as applied, it just simply does not.
Your mystery box came.
doesn't
That is
fit. I
awesome.
think that there are greater questions.
Hope you liked it.
But I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue. So I don't want to say
Rejected
you're
in
the
those-
first.
in all of those.
Right. But it hasn't made it to the Idaho Supreme Court.
PJ will let you know all the
I
holiday
just don't see
soaps
how
that we
as
have.
applied you've provided the court.
We got some
information
good
provided
stuff. I've been
include
working on
that
some really
because your
good
client
stuff.
Is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we
Yeah,
did-
guys, I have to pause and talk every now and then for fair use as commentary. So, it ain't that I'm trying to speak over everything. It's, and this is my show. It's about me talking.
did not submit that argument in our brief.
Ooh, you want a
Think
mystery
as you
stocking?
should.
Yeah, we have the mystery stockings.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes
Hey,
from
Heather.
Hairston, where the court said this just isn't how you do the analysis. You don't accumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With accumulating and then
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating
I think so
factors
too,
is that
PJ.
you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody. It's
But if you have so many
We're almost at 700 likes.
that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said.
Hey, Penny.
That's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. The defense in their reply brief, they tried to say, their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the
They
narrowing
know
part.
he's getting a
They
death
point to
penalty.
Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of TULIPA as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together.
I hope so.
Your Honor,
I
in
hope
terms of
so.
the equal protection claim on geography, I think, here again, they run into a problem with the Idaho Supreme Court.
Thank you, Beverly. I'm glad you
A
guys
similar
like it.
claim based on geography was raised in Harrison, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that. And instead, they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say the courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year a bunch of murders are committed and none of them satisfy the aggravating factors, so now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly.
I
I'm
do
happy
too.
to talk about it more from
Thank
the
you.
Harrison decision.
It's not necessarily a requirement you do, so I just wanted to know. You were fairly summary about it. And it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So a couple of things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
Rebuttal?
Judge, I just wanted to touch on the issue that he raised about Hairston and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, and 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
Do you know what year the Capital Defense Fund was established?
It was after 95. And I think that Hairston may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was after 95.
Issue in your mind?
Pardon?
Just give the man the death penalty already.
No, I think that it
Good
has
Lord.
not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you. I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
All rise.
will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three. And given the time that you've asked, I'm assuming there will be less questions.
I will try to restrain my curiosity.
I'm here. I just ran outside real quick.
And I, as you know, I gave you.
I
some
was getting the
additional
mail,
time.
talking to the neighbor.
That's why.
Right,
Why?
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show, or the distinctions, is that, you know, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the
I'll be right back,
arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, "This court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction." And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, you know, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, you know, similar. Yeah.
Well, so let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument, the one thing that I want to point out about our utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raise the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And
Right.
Right.
Um,
And the
but-
floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's
Judge has his middle finger
the
up.
method of selection with a jury and the
Thank you,
rules
Turtle
about
Gang.
double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional
Thank you,
evidence that would
Kathy.
support
Gifting that
propensity
membership.
that
You're
does not-
awesome.
is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim
The judge
facts
is getting
are
annoyed.
into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I
He's
of
definitely a monster.
1925-19, subsection 9.
If you
And
can do
I
something
think
like
when we're
that,
thinking
you're a
about
monster.
the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says
Didn't
people.
Hall say that it was okay? I can't remember if they addressed that in Hall. I think they
I think
did.
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And I
Isn't
think
that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my
You think this would
client
come
and
after, but they're trying to get
abide
it
by
taken
the
off the
guidelines that are
table.
set forth in capital cases. and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is
Hey,
just a terrible
Zen, how you
judge.
doing
And
tonight?
for that reason alone,
Well, today.
you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing
I'm good.
that
Not too
my
bad.
client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be
He is
struck
the worst
as
of
a
the worst. He
violation of
killed
the Eighth
4
Amendment.
innocent college students.
Thank you.
I say you walk them out back and you put a bullet in them. That's what I say. Now, if he killed one person, yeah, you could argue it, right? But he killed 4 innocent kids that had a bright future. Where's the baby? Okay. Yeah, and they keep pushing it back, so he's not even going to
Your
court
Honor,
to 2025.
beginning with the heinous, and atrocious, and cruel.
Firing squad be nice.
This aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now-
Paul a,
Yeah, he has.
jury,
He won't go to court for a while.
you know,
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically, notwithstanding the fact that I think that I'm the actual judge on the case now. I don't recall because that issue hasn't come up, but.
Thank you, Your Honor. And I apologize.
He ain't never getting out of prison, though. We know
The
that.
defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial clause. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah. I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislature's, not the judiciary's. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity, and those two so overlap that you can't have both. You could still have one, or you could have both. But if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or is probable that they would kill again. I think is the way that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed, but the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
Just execute this man already. Take him out back. Put a hot one in him. Yeah, it'll be 2025, summertime of 2025 when he goes on trial. Right now, they're just trying to get the death penalty thrown out.
All right. I think the
Hey, how's it going?
non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory.
2025, by the time this lady's done
Stay on
talking.
that issue.
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, if I'm being...
So if you look at it like a scale, right? And defense puts on evidence of mitigation. and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
Yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case.
Yep, eye for an
It's
eye. They
important
should
that the
take him
jury
out
have
back
a
and
wide
stab
array
him with
of
a K-bar.
information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance. And that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigation.
When you find a deal on your favorite thing in the McDonald's app and order it, does that technically count as online shopping? Save money with the app. Ba-da-ba-ba-ba.
At participating McDonald's, prices may vary.
And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for, and I think that that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery, and they can bring up any objections that.
I mean, the kids he killed
I
didn't have all these
don't know
rights.
that,
You know, seems like he has an awful
that
lot
this
of
would be an
rights.
issue in
Don't,
the
you know,
case.
can't have the camera too close to me. Got to move the
Unless
court
there are any other
date. Got to
questions,
take
we
the
would ask
death
that
penalty
they
off the
deny the
table.
motion. Thank you, Your Honor.
Like, this dude needs to rot.
Your Honor, I would start by saying thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I
Mopping like
think that
Cinderella.
when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of
Oh, we had a
proof
couple
beyond
soap
a
orders
reasonable
come
doubt
in.
for
Thank you,
those.
guys.
I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters. But it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right
Cindy
to have
just ordered. Thank you,
information come
Cindy.
in fairly, to have
Country
notice of that
candle.
information, and for the state to carry the burden.
Gingerbread.
And they
Thank you
need to
for
carry the
ordering
burden
from
if they
us.
want to
You
present
guys are awesome.
non-statutory aggravating evidence. Thank you.
Thank you.
Dolly Soap makes great Christmas gifts, stocking stuffers. We're going to have the mystery stockings. A lot of good stuff for Christmas. So make sure you check out the merch store. We got the snowflake soap. We got, what is it? Christmas wish. There's a whole bunch of them. I had to look.
You're okay with it. I'm going to swap 8 and 9.
We got spicy cranberry,
because I could see 8
snowflake,
potentially
holiday cheer,
going a little
candy
bit longer,
cane,
than,
Christmas
9, and
cookies,
so,
just to name a few.
well,
Your Honor, can
Yeah.
I help on that?
yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right. Well, let's start then with 8 contemporary standards of decency.
That's the one that Mr. Logston
Oh, he
would
is.
be here. I've got Speedy.
Would you have, who has trifurcation?
Jay's the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge.
You got your sweet tobacco? I think I got your email. I'm
Your Honor,
glad
we're
you
asking the
enjoyed
court
it.
to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history
iParrot.
and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm sorry.
So it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard?
I would say that it's there to provide guidance because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution to as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of Speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate
Thank you,
criminal
Jax.
rule that
Thank
says
you.
that. We don't have a
Welcome
separate
aboard the Dolly
statute that
train.
says
Come
that.
on in, grab you a
We would
seat.
bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been
The
doing
Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the Vallow case. And that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception.
I know they're just trying to take the death penalty out of the table. Everybody, PJ's here to produce.
It's an individualized test based on 4 factors, and you're really looking at kind of the overall.
They're just trying to save his life at this point.
I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays they were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and
what the hell? Why do we keep getting commercials?
Prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case.
Well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the at that time courts were held in session.
PJ says thank you.
What
are you drinking, Dr. Pepper?
And
Claudia,
Right. And then we
where were the rights for the murdered 4 people? And we say the same thing. Thank you, Jack. Thank you, Claudia.
Well, because that was
You guys are
territorial law
great.
at the time. Therefore, that's the constitutional right, and it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and
Yeah, they
and
must.
we don't do that anymore, and so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today, because
Well, my point is that's I think what this defense is arguing essentially.
yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period, and regardless of whether they want
Argument that the 6-month is functionally equivalent of the twice a year circuit.
Oh, that's a good one.
if that is the argument, I don't think that it gets past the Idaho Supreme Court has said no, it's not.
Double
So,
vision.
Under the
There you
Idaho
go.
Constitution, we use the Barker test.
Jack says, "Hey, Dolly, wish you good health
The
and
crux of
happiness,
the matter
man."
here
Thank
is
you.
that
Thank
the
you.
defendant
Same
didn't
to
have
you.
to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So
Yeah.
the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Judge,
3 people have been charged in the
we're
connection.
not trying
former
to
Wonder
graft in a
Woman
time
here.
into the Idaho Constitution. We're
He
looking at the
jumped.
word, the guarantee for a speedy trial.
How do you charge
Figure out
They
people?
what
say
speedy
that
means.
he,
And so
Well,
Well, isn't speedy mean the Barker test?
well, at the time the Constitution was written, I don't think it did.
Isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the
Hey,
court.
they're
It was signed on
unstoppable.
August 23rd,
I'll help you.
2023. Mr. Kohberger signed it, and I assigned with the parentheses attorney. for
Who
the
said that?
defendant. And in that form, and remember, our scheduling
Oh,
order said you
bye.
have to
Don't
do
let
it
door
by
hit
this
you in the
day,
ass.
or you don't get a continuance, you're just going to trial.
Block them.
We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know
We
the
drained
court
into
hasn't.
swamps anyway.
That's it.
Yes, Claudia, it was brutal. The way, he did what he
Right.
did to them kids.
That
That
along
dog
with
is
the other
cute, the little
motions
Frenchie.
will be taken under advisement.
The star of the show.
Let's take a lunch break. It's 5 to 12.
Gonna count the Scott premium?
Yeah, I thought I was on it.
Oh, clearly not. Oh, Lord. Don't. There you go.
One was Roper v. Simmons. Wasn't confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual,
Definitely hit that like button as you
court
come
first
in.
looks at what the state legislatures are doing, and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. They're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think I think that's Abdullah where they had said that. And I think that was partly because the way that it was and in those cases, it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hurston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those.
I thought this would be quick.
True.
They've been going on and on about this death penalty thing.
That still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So, for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it?
PJ's all happy. We sold a mystery stocking.
So the Idaho Supreme Court did mention executive action, although in Hurston they seem to say
don't forget,
the better picture is
we don't put a lump of coal in the stocking.
And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think,
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
potentially, yes. But I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both of
PJ said this is the definition of kicking a dead horse. He's definitely
Your
a
Honor.
dead horse. It's just a matter of time.
I just never heard of this type of argument happening before the trial.
Just
Like,
briefly.
Well, if they're going to
why-
get the death penalty thrown out, they want to do it before trial. They don't want to do it, try to do it after he's been given the death penalty.
I would caution
Right, I guess
the
that
court
makes sense.
trying to
Claudia, who thinks
figure
in
out
chat
why it
Kohberger
is
is guilty or
that the
innocent?
state either dropped
If
the
you-
death
Really think
penalty
he's innocent?
or
If you think he's guilty,
imposed
press
a
1. If you think he's
moratorium,
innocent,
I
press 2.
that
Okay, let's see what the
these things are
chat thinks.
complicated. That
Jax
looks
has
an
just
awful lot
renewed
like
his
trying
membership.
to figure out what from
1
legislative
guilty,
history,
2
why something
innocent.
occurred.
Let's see where you
Half
guys
the
are at.
time, what you see in the questions doesn't
Did you tell
necessarily tell
somebody
you what
earlier that
the
you were
legislature had in
50-50?
mind when they finally
No,
I didn't think
Um,
so.
and so I
I was like,
think
where have I
a
been?
lot of people are
first
thinking
step,
guilty.
as the United States Supreme Court has
Guilty.
set it out,
I mean, just
just to look at the
at
numbers.
Right there.
After
There's
that,
somebody that thought it was
courts
innocent.
can
eyebrow
consider
profile.
other things.
It's them thick eyebrows.
That's it.
That's what got them.
Gave you
How-
away.
we certainly
2
more than
framed by the
third
police, says
states. How
Denise.
does that represent a consensus?
Laura says 1, 2, 3,
I
4.
would argue that
Deborah says 2. Sunset says 2.
consensus can also come from the trajectory. So the fact that
Mab just
so many
gifted a
states
membership.
dropped
Thank
the
you,
death
Mab.
penalty within the last few
KC says
years,
2.
and that appears to be the direction that things are going. Is something that the
Marcel
court
says
can take
2.
into account. I
think
also
Raymond's
note
working on his mannequin
a
challenge.
lot of these states that have
It's like he's
death
asleep
row
sitting there.
and don't have
What's up,
moratorium
boy?
still aren't actually
Uh-huh.
executing it.
Jake?
And so the
Jake?
actual number of executions in the states that are actually executing anybody is
He's
less
just a big
than
old love bug.
something like
Hey,
13
big old
jurisdictions
boy.
that are actually doing executions.
He's a heavy love bug.
Anyway, for those reasons,
Rhonda thinks he's innocent too. So there's a lot of people in here that
Thank you.
thinks he's innocent.
All right.
I mean, there's way more that think he's guilty, but there's a lot of people that think he's innocent
I
too.
mean,
Motion to
There's a
trifurcate
little bit of
the
conspiracy
proceedings
and some
and to apply the
questionable
rules
stuff,
of evidence in
but,
the.
I mean, compared to
penalty phase.
Richard Allen, there's a
Um,
lot more.
So, Your Honor,
He's a baby. He's a big old baby.
I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same.
You don't
thing.
think he's done it alone? Okay.
If it's not trifurcated,
Which case was that?
I want to
that
know
was
where,
Renfro.
where all the blood went.
Renfro.
Yeah.
It's
Why
not
didn't he have
trifurcated.
blood all
What
over
happens
him?
at the in the penalty phase? Is
Can we get
that the
Delaware
state
and buy
would
this?
Be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those
What's
things.
so special
Isn't
about
there
it? Where did they put
a
it?
post-conviction proceeding in which it's alleged?
You really
that
are into
was,
this
ineffective
weirdo,
assistance to
like,
allow the
the movies
trifurcation
aren't even good.
because you make.
Yeah, but I like
the jury,
him.
Decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision.
You didn't, and I thought you did. I'm sorry.
Sure, there is. But I can't say that I agree because from a jury's perspective, I mean, you have to realize that
Where's he going?
I have no idea.
These are people who have been pulled in. They don't have legal training, and now you're asking them
Well,
to
where is
make
Jim?
a bunch of different decisions at the same time. And as we pointed out, I mean, we can go back and forth about, what's the if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so, I mean, we can go back and forth about, who does that prejudice. At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating,
Claudius,
aggravating?
it's a gut
you can put
instinct,
on
but
some
can you
mitigating,
chat say why you think so?
depending on what the aggravator is.
I mean,
and the
one, there's
aggravating
eyewitnesses
portion of
to
the
it. Two, his
case.
DNA was
And
on
we
the
can talk
sheath.
about
He ordered the
the
sheath,
dangerousness and things like that,
right? And
assuming
we
the
know
court
he
decides to
ordered the
let it in.
sheath,
Yeah.
But
right? So he
if
had a
there was-
K-bar
do it this
knife. So
way,
that's a lot of coincidence.
what
there
you
was a
risk
DNA
is that a
force
jury is going to be
on,
influenced by
Richard Allen,
non-statutory
that would be a wrap
aggravators,
for me.
victim
Yeah.
impact statements.
I think
On
there's
those
more evidence
grounds,
against Kohberger than there
say
is
yes to
Richard
all the
Allen.
statutory aggravators. And, you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think, under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators. And then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said confrontation clearly needs to be able to apply. We have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. That's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in. So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence in mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law. And the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that case. We put on evidence that pushed back against that at that point in the case.
I mean, just execute the guy already. I want to do it now before the trial.
From
Good Lord.
the jury's perspective, it was cleaner from our perspective. I
Yeah.
don't think we even argued about it.
They can't get the
state
drugs
came
to put
along
you out
with
your misery.
it. And I thought
They're
it
saying
was
they can't get the drugs to
well.
execute.
Um,
That's why they don't want them executed, because they don't know if they can get
And
the
I-
drugs.
I
And he would
definitely
sit
wanna
on
push
the-
back on the idea
They
that
just said
you know,
there
we-
was
we have a tendency
investigation
to
people from the
have
80s.
these
So how long is it really going to take?
tautologies
He's just going to be
in the
sitting
law
there
where we say,
chilling.
well,
It's
the
like
jury,
what, 20 years from now?
is great,
Yeah.
they'll figure
And
it
then
all
when there
out,
becomes a
so long as
Democratic
we tell them
president,
what
they
to
won't
do,
execute you.
then
That's
they
why
will
they ain't
not
been
do what they've been
executing nobody.
told.
That's what the lawyer said. He said soon
There
they'd
are
probably be
studies that show
executing
that's
because
just not accurate.
you know,
When
you
this
have a
jury brought up
Republican in
project,
office.
you can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we, really think hard about how
Yeah,
people are going to make
Idaho
these
has the
decisions.
firing squad
If we're going to do
because they couldn't get the
normal,
drugs
just a
to
penalty
execute
session,
people, so they brought back the firing
That's
squad.
going to require
Drugs earlier.
some additional instructions.
Let's
I
play
know the
what
Supreme Court just
the
recently
judge is
updated a lot of
thinking.
the
Oh,
ages,
sorry.
which is
I knew I
great.
should have got out of bed.
Something
I
that
knew
I've
I
been
shouldn't have got
advocating
out of
for.
bed this morning. Says
But
Jax.
there
What is
are
the
additional
damn
things that I
judge
think are gonna have
thinking?
to
He's
be told
thinking, man, it's
to a
going to be a
jury so that they
long
can
day.
understand how that would
When
function.
it started,
If we trifurcate
he had
it,
hair.
It's going to make it simpler for
Judge
them
is
to
thinking,
understand.
I feel sorry
Okay,
for that lady's
you know,
husband.
you've now
Mhm.
found this person guilty. Now you're going to
The
be
judge is
determining whether
thinking,
or
why
not
does
these
this lady's
statutory
hair
factors
match her
exist.
jacket?
This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going
Karen
to
says
do
her
an
son
opening
has a
statement and a
Frenchie.
closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case, why those statutory aggravators
There you go,
don't exist.
Claudia.
You're
What
gonna
kind
make
of
that
death penalty
determination.
exists in
If
the
you make that
U.S.? There
determination,
are
when
more
we get to a
options can
sentencing
criminals
proceeding
choose,
where
and when they're
the
convicted,
state's going to be able to
there's
put on any
stoning.
additional aggravators
There's
that
the
it
firing
has
squad.
put on,
Yeah,
and the
a
defense
dude
can
chose
put on,
stoning,
any
and they didn't
other
want to stone
information
him
that
because they thought it was
that's gonna be
inhumane, but it's on the books,
It works,
and
and it
they
worked,
gave him a stay at execution.
regardless of whether or not the SAPD.
So they
doesn't
gave
do
him
it.
life
Um,
because he chose
and
stoning.
it's
They didn't want to stone him to death. There's stoning,
I'd
there's
ask
the
the court to
firing
consider
squad,
it.
there's the
Certainly if the court decides
lethal
not to do
injection,
it, we'll
and
have
there's the
lots of
gas chamber.
conversations about how best to
Electrocution
do
is
that
out.
It's
procedure.
intriguing
I don't think they
idea.
use Old Sparky
Concern,
anymore.
Of course, is
They do have the gas chamber in
it's
Alabama, though. They
executed
just
this case
executed
once,
somebody not
twice,
real long ago with
Right.
and there's a
I
the
thought
gas
it did
chamber.
protocol that has been approved.
No, it
by
did.
the appellate
did.
bodies.
The last
It's just
person that
one
didn't
they're
work was the
proposing
Creech
now,
guy,
so
and they couldn't
that's
find a vein to lethal
always,
inject him.
in a trial judges who tend to be fairly risk averse, difficulty.
I mean,
If this was Judge Tammy Stokes, he would have done took 30 breaks.
well, I
All right,
don't
my
understand how you
dance
don't,
sheet
like,
indicates that we have
if you're
covered all
halfway
the
dead, you
topics.
won't find a vein. What do
Did
you
I
mean
miss
you couldn't find,
anything
you
from
couldn't find a
either
single
board
vein on his
perspective?
entire body?
That's what they said.
No motions, Your Honor,
Yeah,
but I think
I don't
Ms.
know about
Nassa
that.
has one thing.
One
Okay.
housekeeping.
Sure.
Oh, look how
Yes,
evil
we
that looks.
submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal, definitely with the PowerPoint. We have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with, you know, the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed.
If you survive the death penalty, they don't kill you.
What?
The
Yeah.
redacted version,
So,
so that they,
what's
as much
the
information
point
as
of
we
all
can.
of that then?
Yeah, they can't try to kill you again. Look, there was a guy
Thank you.
that was in prison and he had a heart attack and he died.
For today.
Right, and they brought him back.
Nothing else.
And
for
he wanted to
today.
be released
There was
because he
a
said he was
motion
sentenced to
filed,
death
got placed under seal
until
by
he
the court
died,
when
and he
scheduled.
legally
That about
died.
your
and was
jury
brought
voir dire
back.
procedure.
He wanted
Yeah,
out
I
of
think
prison.
that's probably more.
They didn't let him
appropriate to
out, but
take
he
up as
wanted
we get
out
closer
because
to
he said he
pretrial,
died in prison.
Than anything, because it really
He's
deals
kind of
with.
right though.
Yeah, if you sentence somebody to life in prison and then they die
Essentially what
and they
is
come
and
back to
isn't,
life, you know what I'm
allowed
saying?
in voir dire
You should let them out,
so,
right?
I think it's just a little early in the game yet to get to that.
Yeah,
From
people
my
have survived the death penalty. People have survived the electric chair and been real fucked
Your
up.
Honor, the only thought I have about that is perhaps talking about that.
There's been a dude that they
may
tried to
cause the
lethal
court to
inject
think we
that
should
survived.
begin.
There's
court
been
maybe it's time to get it
nobody's
earlier
ever
than
survived the gas
currently
chamber or the
scheduled.
firing squad.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's
I
in
would trust the
May.
court on that.
And our voir dire is set to begin in August or late July. I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today, that it was probably something we could save for a later day.
Fair enough. Thank you.
All right. Anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why I sealed that, I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of Venermen because they've read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.
All rise. Court is in recess.
That is it right there. So he's definitely getting a death penalty. They're not doing away with the death penalty on his ass. So let me pause.
Customize and
Pause that. Okay, hold on. My kid is calling. Give me 1 second, guys. You want to take over for a second, PJ? All right, here. I'll cut the cam off. There you go. Hello.
All right. Whoa. Do you want to open the phone calls? If I want to look back. Oh, okay. What am I going to talk about, you guys? So what do you think? Why did they end it like that? They just went for recess and then it was over?
I don't know if they're going to stay for a low ball.
Hello. Get over. Get over so I can sit. Hello.
I will. I'll get rid of the G.
Maybe get set aside but now, okay. I'm just trying to read what you guys are saying. I don't know why this is over here like this. Watch out, Lo. Oh, okay. Now we're up here together. Hey, guys. I wonder if I can figure out how to do a phone. Open Sesame. Rangy. I might possibly have just turned on the phone line. Okay, now I have to figure out how to get this to be over here and this to go away. I lost you guys completely. Ah! I messed that all up because now you can see the stuff. He's going to have to cut that out. I messed that up. Wrangler. And now he's trying to come up here. All right. Forget I did that. I quit. It's on though. The freaking phone line is on. I know, Jax. I messed it up. I can't help it. I break stuff. But I mean, it's just random numbers. You don't know who's who or what. It's not like they have names next to them. He's going to be done in a minute. But I did turn the phone line on if anybody cares. I don't think. Let's see. Maybe I can figure it out. Wait. Okay. There's this. I know. It just was random numbers. Nobody, like, you're not going to decipher who's who just by, looking at random numbers. It's okay. They cannot get him on DP. Not enough evidence. If they found skin cells, blood, sweat, etc., it seemed they... Phone lines are on. I was trying to get him to hurry up so that I wasn't just sitting here on dead air, but let's see. I just called and it went to voicemail. Oh, I must have not done it right then. I don't know. That's weird. Let me try something. Ah, that's why. Okay, I get it. I know what I did. Oh, no. We're that low. Okay. Yeah. I suck at this. I guess I might be better if I was like veteran, but let's see. I swear I thought I turned it on. It said it was on. No, stop. No. Nope, it won't open on that one. Ugh. We're just sitting here just staring at each other. I didn't fix it. Hold on. I'm going to fix it. It'll just be a second. Sorry. And I did receiving calls. It's on. but I didn't share the screen or the volume. Sorry, guys. I'm usually not this bad at this. No. Jimmy! Never mind, I figured it out. I figured it out, never mind.
Oh, you're taking calls?
I was trying to, but I can't find my ringing button. And then I accidentally showed a bunch of numbers, but it's just random numbers. It's not like they know who's who. But there it is. This is BJ. Who's this and where you calling from? Hey. Bye, BJ.
They just called to say hi, PJ, baby.
Yeah.
Okay.
There's thank you. I think I wanted to read that comment.
There's no sound.
Oh,
Hold
I
on.
didn't share the sound.
Oh, okay. Hold on. Now there's sound.
How can you tell?
Because I shared the screen.
I shared the screen too.
No, see, it says remove. That
Oh, duh.
all right. So now the call.
Now you
we
can call
hear
in
calls
and we
now,
can hear
guys.
it. Sorry.
So if you want to talk to PJ, call
This
in.
is a lot harder than it looks. See?
Just answer it.
This is PJ. Who's this and where are you calling
Why
from?
you so low?
Hey, PJ, it's
Hey,
Brandy.
Granny.
How are you doing?
Good. How are you?
I'm doing good. You're pretty as ever.
Thank you.
It's calling to let you and Dolly know they're fixing to put another one to death down here
Oh,
in
Lord.
Alabama, the 21st of this month.
You're just following
that'll-
everybody that's set to die then, huh?
Oh yeah, this makes the third one
Wow.
with that nitrogen.
With the gas. Holy cow.
Yeah.
How long have these people waited to go?
Well, this one 30 years.
Oh my God. That just seems
30 years. He got to live 30 years, which I don't think that's right.
I don't really
No,
think so either. It just seems like
No, that's too long.
yeah, I agree.
That's too long. 4 or 5 years is it. And if they can't prove themselves innocent within that 4 or 5 years, they need to go on and do away with them.
I agree.
And that's just the way I feel about it. But yeah, he'll make the third one in 2024 that they put to death like that.
That's
So
crazy.
evidently, Alabama has found a way to do it
I got
without
peanut
those
squirrel.
drugs
Oh,
that are too hard to get.
Right.
And I wouldn't want to die like that. I think I'd
No.
want to shoot me.
I mean,
Shoot me, please.
right, because that would be faster than
Oh man,
I wouldn't either.
nitrogen would be a terrible way to go. Just shoot me right in the head.
I can't even imagine. That's horrific. So do you think they proved their case?
Oh yeah, yeah.
No, but I mean that they were arguing today about Bryan Kohberger.
Oh no.
I didn't think so either. I feel like she said the
No.
same words over and over and over. It hurt my head.
And good God, who's ever heard of that before their client has ever gone, found guilty?
Well,
Those should be
I guess it makes sense because if they wait to do it later, which I don't think they do wait, because remember how when Leilani came up, they didn't the death penalty was already off the table. So like certain stipulations, I guess you don't have the death penalty automatically based on your charge, but I guess if they had it on the table, then they would have to argue it after the fact, and then it wouldn't make sense. I kind of understand it, but at the same time, this feels like a whole case already.
I know.
It's like we just sat through a trial day.
Well, the defense must not. They must really have something on Kohberger for the defense to be fighting this hard, not to put him to death.
Yeah.
they've got him nailed,
Yeah.
and they know it. So the most they can do to help him is to get it to where death is off the table.
Take that comment off, Sherry.
And I don't agree with it.
Yeah.
I am death penalty. You know,
Yeah.
if they kill somebody, especially in the way that those girls were killed and the boy.
Today is when they
No.
granted the stay of execution of the guy that tried to execute by injection 8 times in Idaho. I don't understand. And I don't understand how they couldn't find a vein. That just makes no sense to me. There's literally hundreds of veins in your body.
Well, they should have went in the artery.
I mean, something. It just seems like, I don't know. It just seems like we're just doing things incorrectly nowadays at life.
I know
Many
it.
veins, it's possible.
I mean, I
Well,
guess.
well, it could be drug abuse, and they've exacerbated every vein they've got. But there's ways around that.
Mm-hmm.
Just set it up in an artery.
I mean, it's
And-
almost
and
as if
go
they
in
didn't
it
really
like
actually
that.
want to do it. They just wanted to say they were going to do it.
I don't know. Down here in Alabama, though, man, they found a way, and they lining them up.
Yeah. It
So,
seems that way.
well, I just wanted to holler at you, baby. You look so pretty.
Thank you. Thanks for calling.
I love you.
Love
What's
you.
top notch?
Have a good night, Brittany.
Tell buy Goofy over there a helmet.
We need to buy him a helmet.
Buy him a helmet.
Buy him a helmet
Mhm.
and wrap him in bubble wrap.
I
He even grunted a little bit. when
know.
He failed. I laughed. I'm sorry. I laughed.
We all did.
I love y'all. What's top notch?
You too, Granny.
Bye.
Bye. She said she laughed at you.
I know, a lot of people laughed. I'm okay, though. I survived.
Well, that's all that matters.
Okay, you ready to get out of here?
One more call. This is PJ. Who is this and where are you calling from?
This is Doug from Tennessee, and I get to make fun of him too.
What did he say?
He said he gets
Two in a
to make
row.
fun of you too.
Oh,
Yeah,
make fun of Dolly Day.
yeah. We keep see PJ laughing. Did you get to watch the video,
Which video?
PJ? Huh?
Of me
Which
falling?
video?
Yeah, him falling. You got to hear it.
Yeah.
I got to hear it. I have it on loop on my phone.
Oh, it was loud.
It was really loud.
Yeah, it was. I still feel it.
Man, you got a knot up on your eyeball.
Mm-hmm.
I know.
You'll be
My
all right.
elbow's the worst, though.
I got a question. Has that dog missed any meals?
No.
No.
I bet it's a lot more harder to hold that dog than it is Lolo.
Yeah, he's a fat one.
He's only 22 pounds.
Oh,
He's
man.
not that big. But he
Yeah,
thinks he's a
well,
lap dog. He thinks he just look at him. He's just gonna stand there now. And
he's
he
doing a
thinks
pretty
he's the
good job.
star. He thinks he's the star of the show.
Hey,
Do you
but I
notice
do
how
say
he
one thing.
adjusts himself? He adjusts himself so he's in camera view at all times.
Yeah, he heard Doug.
Mm-hmm.
Hey, I do say one thing. If Kohberger is guilty, they do need to execute him.
Or don't tell me you
But
don't think
God-
he's guilty either, Doug.
I just can't see one man taking out 4 people that quick. He's not that bad of a man. He's not that good.
Mm,
That's 4 people,
That's a
dude.
good
That's
point.
hard to do.
that's a good
That's
point.
hard to do.
That is. a
I
good
just believe
point.
there was more. I believe there was more people than one,
Yeah.
and he was just involved in it, and he got scared and ran.
Yeah, but why wouldn't he give out other people, like to save himself?
I mean, he's
Well,
not
if he
guilty.
didn't,
Well,
if
wasn't
he,
he one of the ones? Wasn't he the one that said,
Did
how?
you arrest anybody else?
Yes. Isn't that another
Yeah.
famous thing another killer said?
that's why I'm saying he dropped them off. He dropped them off, and he heard all that gore going on. And he hauled ass.
This is Wrangler.
He didn't say what?
Oh, somebody
He was talking to
asked
the
what
chat.
puppy it was. This is the Frenchie
Oh.
Wrangler.
Dude,
He's a big old Frenchie.
him and Lola are sniffing each other on my lap, and this is gonna be fun.
But yeah, if he is guilty though, they do need to give him the death penalty.
Yeah, because that's one too many
But
people
I
he
just
took
believe-
out.
I just believe he was an outside man. He heard all that shit going on, and he left them
Hmm.
and all that.
So then why'd he come
That's
back
what
first thing in the morning?
But see, he would still be guilty because he was associated with them by fact.
Yeah.
I mean, you're not robbing a bank. You go in there and somebody shoots somebody in the bank.
Well,
You
they
have to
have
drive in the getaway car.
They have his cell phone on the cell tower in the vicinity of the house, like at 9 something the next morning.
That's just because he's coming back over to collect his money.
Mm.
I
Okay.
just believe it all had to do. I believe it all had to do with drugs.
Yeah, I can see that because of the time that it took for them to call the police even. So yeah, I could definitely see that.
But I believe it was more than one person, and he got cold feet and left.
Yeah.
But he still as guilty as they are.
Yeah.
Whoever done it. But they'll,
I mean,
they'll prove it though.
I think he'll be in a lineup with just his eyebrows, and he'll be caught.
Yeah, they will. All right, well, I'll let y'all go see you, PJ. Bye, Dolly.
Bye.
Later, Doug. Okay, guys, we're gonna get ready to get out of here. So, Bryan Kohberger definitely getting the death penalty. That's what I think. Good to see everybody. Do you want to say bye to everybody, PJ?
Bye, PJ.
Bye, PJ. All right, y'all be good. You gotta.
I know how to
We'll
do
see
it.
y'all
I thought you
later.
were going to say more. You usually say like a paragraph before you leave.